Call tonight's show The Audit That Never Was. And John Brakey is here, and he's going to tell us a little bit about it. But we have on the phone, we have the attorney for a new lawsuit. But I really want to go over what happened and yesterday at the Board of Supervisors and today. And so we have Mike Kielsky, the attorney as well for the Libertarian Party. And I want to welcome you to the show, Mike, and tell us a little bit about what's been happening. If you want to give more details
If I could
about
say,
his background.
Well, I just want to say I've known Michael for about 15 years. This is not the first rodeo him and me have done. And I think this could be number 4 or 5. He's an outstanding attorney. He's run for county attorney. He has been very heavily involved in the Libertarian Party for at least 15 years, I believe, and has been a real champion of the people standing up. I'm not going to say he's an activist attorney, but I would be proud if I was an attorney and somebody called me an activist standing up for the American people. Mm-hmm. And that's what Michael has done.
Thank you.
Okay, you have been the attorney here for this lawsuit, so why don't you tell us what this is about? I've seen some of your performances on the Zoom call with the judge, but tell the listening audience what this lawsuit is about.
Well, it's about nothing more or less than the Maricopa County has gone ahead and been really public about this thing that they call an audit, which is clearly not an audit. And in the process, they have made a number of different public pronouncements which are clearly false, including, among other things, that they've invited the political parties to play their role and observe and provide the supervision, so to speak, for what they're doing. And so, despite their public pronouncements that the political parties have been invited, all the political parties have been excluded, and the Maricopa County Libertarian Party, who was one of the parties that has participated in, for example, the logic and accuracy test and the hand count and things like that, before and immediately after the election, has been excluded from this process, and we just felt that they're violating the law. And what's more egregious is not only are they violating the law, but they're lying about it too. And so we want to hold them to account. And Maricopa County has a history of doing this. We have several times had to go to court and point out to the court system how Maricopa County just chooses to flout the law, chooses to ignore what they're required to do, and much of the time they do get away with it, but sometimes they don't. And the only way you know when they're not going to get away with it is by bringing an action like this and pointing the law and the facts out to the court and have the court smack them down.
Well, I was really surprised. I didn't have a chance to see the hearing. Was it yesterday? I guess yesterday morning. But I did the week before, where the attorney comes in 15 or 20 minutes late, and then says, "Your Honor, pardon the way I've dressed. I didn't know that we had a hearing today." I find that appalling. And if I had done something like that as a defendant in a courtroom, I'm sure the judge would have admonished me severely for that. But I didn't see that happening here.
Well, okay, so again, this is the different standard that applies to government lawyers and everybody else. So right there, and you saw that live in action. Anybody else that comes into courtroom and says, "Judge, I didn't even know we had a hearing. I didn't even know there was a case on," even though they were served 6 days earlier, and the paperwork they were served was clearly provided the court date when they were supposed to be there. So again, that's part of the culture of the court system. Sometimes they can be much too forgiving of government lawyers. So it was inexcusable that he said I didn't know there was a hearing. And what was even more outrageous is that then he said, well, Judge, I don't even know why we're here. We're not conducting an audit. I don't know what they're talking about. There's no audit going on.
Isn't that amazing?
And that was just absolutely jaw-dropping because, in my mind, that was just, outright deceiving the court. So not only are you trying to make an excuse for something that's inexcusable, which is, well, I didn't even know there was a hearing. Well, you had notice of it. You had the kind of notice that everybody in these kinds of cases gets, and you just decided at the last minute to say, well, I didn't even know there was a hearing, and then you waltz in there and you say, but Judge, they got this all wrong. We're not conducting an audit. What are they talking about? There's no audit going on. And meanwhile, once again, the county has widely publicized their, the fantastic results, the clean bill of health they got from their mock audit. Well, again, that's how you know that it's a mock audit. As somebody who has seen audit results, if you ever get an audit result of anything that's audited and there is not a single item that you're faulted for, then you know it's a fake audit. Because even when you do things as close to correctly as you can, the auditors will always give you feedback and say, look, you passed the audit, it satisfies all the standards, but here's some areas of concern. Here's some things that you need to watch out for. Here's some processes and procedures that put you at risk. And none of that in this mock audit that they're crowing about yesterday and today, none of that was in there. Everything was 100% perfectly. It was the most perfect thing ever, and that is not an audit. And right there, anybody that's ever been involved in a kind of audit or reviewing audit result documents will know exactly what I'm talking about. You always get feedback on risk areas and things that are okay but should be better, and so on. And none of that is here. But getting back to the court case, so that was also incredible. On that very first time we came to court, so the judge gave the county a couple of days for them to speak to me, and then we would reconvene and we would tell the judge what we were going to do next. Well, so the next thing that happened is I did speak to the attorney for the county, and the attorney again said, look, if you just understood what we're really doing, you would know that you don't have a case and you would dismiss it. I'm like, all right. And we have this document, we have this scope of work document that'll tell you exactly what we're doing, and you will know that once you see that, you will know that you really don't have a case and you need to dismiss. I'm like, all right, well, give me that document and we'll look it over. I'll discuss it with my client and we'll see what we do. And then I get a call. I got a call the next day saying, well, I'm sorry I didn't get that to you last night. We're still working on getting that to you. But once we give that to you, you'll dismiss right away, right? And I'm like, well, I don't know. It depends on what's in this document that you're going to give me. And the next thing I hear Sunday night is I get an email from the attorney from the county saying, well, since you guys aren't going to go ahead and dismiss, we're not going to give you that document. That would just clear all.
Are you kidding?
Outrageous.
Yeah. So then we go into the hearing on Tuesday, and basically explain that's what happened to the judge. I say, look, Judge, first of all, they told you there wasn't an audit, and then the attorney for the county that it was a different attorney coming in. The attorney for the county that time said, oh yeah, Judge, we're doing an audit. And I'm like, Judge, do you remember the other day when they said there wasn't even an audit? They did, that we didn't even know what we were talking about. And so the judge said, all right, well, so the county wants to file a motion to dismiss, so they get some time to go ahead and do that. And since the county says they're already done with the audit, then the time pressure is a little bit off. So we're going to go ahead and give them time to file their motion to dismiss. Then you get some time to file a response, and they get some more time to file a reply, and then we'll have a hearing, and that hearing is set for basically at this point the middle of March.
Oh wow! I was amazed even when you pressed them to have a response the following day from the first hearing, and the judge says, "Well, that's not reasonable." I thought, "What do you mean it's not reasonable? They already said they were going to file a motion to dismiss, and they had notice, I think, Ray, for what?
6 days.
6 days or more?
Yeah.
And they didn't know that there was a hearing, and they didn't have a brief prepared?
Yeah.
That is
This is government attorneys for you. This is what happens when government attorneys are on one side. They just, they get away with so much more than attorneys that are not government attorneys in most cases.
Now, John,
And
go ahead.
yeah, it's absolutely mind-boggling, and there's just so many things that just make your head spin about this case, and including, like I said, that almost was sort of a head fake. Like, we're going to give you this document that's going to clear everything up, but and then you'll dismiss because you'll be clear that you don't have a case. Well, since you can't promise that you're going to dismiss it as soon as we give you this document, we're not even going to give you this document, and it blows my mind. And again, of course, this is a document that's a public record. So what's the harm in giving it to me now, just in case there's even a small chance that we might be convinced that we really don't have a case? No, they play this. It's almost like a tit for tat sort of juvenile game. Like, well, since you're not going to go ahead and dismiss, we won't even give you this document now. Well,
Now we read something here on the Monday show that John Brakey had brought in with regard to a Supreme Court case, because you believed that they would try to say, well, listen, it's already over, so it's a moot point now, and we really don't need to continue with this. Can you talk a little bit about that Supreme Court case?
well, I mean that's a common. It's not just one case. It's a common standard that applies in Arizona, and that is the standard that says capable of repetition yet evading review, and it applies in a lot of case contexts where by the time the case can go all the way to the Arizona Supreme Court and could be reviewed, a lot of times the side that's on the originally winning side will say, well, Judge, it's moot. There's nothing for you to decide. It's already been, it's already done. It's a done deal. The building has been demolished. The road has been built. The property has been seized. The person has been executed. It's moot. And so then the other side will say, well, Judge, no, this is an important legal issue, and the court needs to decide this not only for this case, but to explain what the law really is that applies here. So in any future cases, if this issue ever comes up again, we have clear direction from the court. So it's the capable of repetition yet evading review standard. And it applies especially in election cases, because election cases happen on it's almost a breakneck speed, where they go so super fast, and they have to be over and done with because ballots have to be printed in most situations, and elections have to be certified, and this, that, the other. So they have to go at a hugely fast pace. So again, I think there's a chance, and they did it in the last hearing. They tried to say, well, Judge, it's already over. It's moot. And I made the point that, look, Judge, this is an issue. Whether the audit is over or not has first of all, doesn't have anything to do with one of our claims, which is for the judge, the court to declare that this audit is not an audit. It's null and void because it violated Arizona law, and so it was nothing. It was a nullity. So from that perspective, it isn't moot. And even if it were conceptually moot because it's over with, it is one of those situations where, again, it's capable of repetition and yet evading review because the county, because of the actions of the county that have made it, impossible for the court to even consider it and rule on it because, like we've already talked about, the attorney for the county comes in and says, "Oh, I didn't even really know there was a hearing today." All right, fine, we'll come back in a few days. You got a chance to review it, and then they come back in a few days, and they're like, "Well, we haven't really decided anything. We haven't filed anything, but we promised we're going to file something. We just need lots of time to file our motion to dismiss," and the judge gives them 2 weeks.
Amazing.
So, again, that's where they're really setting it up for this argument that they're trying to make the harm, or they're trying to make the. It's so far in the past now that, Judge, it doesn't even matter what you rule; it's moot. And again, this is what they're trying to set up in part, I think.
Is there any chance that the Attorney General of the state of Arizona might intercede in this fiasco? I mean, this has been a clown show all the way through. is there any chance Branovich may say, hey, you better turn the records over?
Well, I mean, I would hope to the extent the Attorney General has taken an interest in some of this litigation, the Attorney General would do that. And again, remember this: there are already several lawsuits, I believe, now consolidated between the Arizona State Senate and Maricopa County. And I think the most incredible part about that is that in that lawsuit, the county is essentially saying things that are completely the opposite of what they're saying in this lawsuit. So in that lawsuit, I believe they've been asserting to the court that, well, Judge, we can't turn over these ballots because we're in the middle of this audit thing, and that's why we gotta hang on to these ballots, and we can't honor the subpoena of the Senate. And again, so they're using this mock audit as a way to fend off the Senate subpoena. And in our case, I believe they're taking, like I said, an inconsistent position in saying, well, there isn't even an audit, or what you think is an audit isn't really an audit, it's something else, although we're constantly calling it an audit on all public pronouncements.
Yes, I don't know if John has told you about my background, but I've been an auditor for most of my life, including with the Auditor General of the State of Arizona. This is not an audit, not even close. I don't know what I would call it other than a clown show.
Now, John, were you able to submit this request to the court?
Yes, of course.
We
Michael
talked
has,
about this.
Michael. I had Michael look at it over because I didn't want to file anything without his permission. And before I filed yesterday, I talked to Michael, and he says, "Hey, you're independent. Go ahead and do it." And
so this is the public record request, right?
for the ballot images, we're trying to get a shortcut. We don't need to look at everything. We just need to get those images. We need to go ahead and get them processed, brought back in 743 batches that anybody can count, and then we will run the whole ballot through another system and then check the accuracy and then allow it to go to the public for the public can verify themselves, because purely elections aren't any good unless they're transparent, trackable, publicly verified. That's the mission as Americans.
Right.
Michael, you've done this before with John. Is this the craziest thing that you've ever seen?
No, I don't think it's the craziest thing I've ever seen. I mean, John and I had a case many years ago where we ended up having to sue Maricopa County Elections because we had some elections observers that Maricopa County Elections was just like, no, you can't come into our election center. These are official observers appointed by the Libertarian Party. And so we went in front of the judge. The judge looked at the county people and said, what's going on here? And they're like, yeah, we're not going to let this guy in. And the judge goes, well, why aren't you letting this guy in? Well, we have some vague security concerns that, we know the guy sometimes carries a gun, and we know he's got this camera and he's going to take pictures, and so the judge, looked at them like, well, can't you screen him to make sure he's not carrying a gun when he comes in? Well, yeah, we could do that. Well, can't you ask him not to take pictures of those things that he's not allowed to take pictures of? Well, yeah, we could do that. So the judge, very quickly ruled, no, you can't just keep him out. He's the official representative. You've got specific security issues. Go ahead and deal with it at that point. But if you're just making these vague assertions that you're afraid that it'll do these things, then that's a case that we won. There was another case that we did a few years later, also involving Maricopa County in their election shenanigans, and where we pointed out, and John is quite aware of this as well, where where just like in this round, where they did the hand count, but they followed the wrong process.
Yeah.
And we pointed that out, and the judge heard all the evidence, and the judge at the end ruled, the county didn't follow the law. They violated the law, and the county don't ever do that again, and that was the end of that.
So what is it? Just a slap on the wrist? Is that basically what they get?
Not even a slap on the wrist. A slap on the wrist they could actually maybe feel. This was like less than that. This was like a a little bit of side eye.
Mean look.
And you know, that case that Michael just talked about was in 2008. In 2008, they counted 18,000 ballots. I want you to know, in the primary, in the general, they only counted 8,000. And we're 40% bigger now than we were then.
Yeah,
Back then, we counted 23 precincts. Now they're counting 4 voting centers, okay? It is an audit that doesn't prove anything except, you know, that they counted a few batches that we've talked about earlier, but it's incredible. And that's where I'm grateful to attorneys like Michael Kielsky. He's stand by our democracy and fight with us. And Michael, I'm very grateful to the relationship that we have and all the years you've had to put up with me.
And let me point something out to the audience. Those of you that are steady, you know what I'm going to say when I talk about this is a bipartisan issue.
Absolutely.
Because John is a Democrat.
Progressive.
Ray and I are Republicans. I
Practically
don't know
socialist.
what Michael Kielsky is, and yet we're working with the Libertarian Party as well.
Because we're Americans.
Because we're Americans.
And
and
the
we wanna
Greens are
make
with us
sure-
too, and we'll be bringing the Democrats involved. I just got to go out there and remind them.
And I understand that the AZ GOP, Michael, just verify this, that the court did accept them as a friend of the court amicus brief.
Yeah, so yes, the Maricopa. I'm sorry, I'm not sure it's Maricopa County or state.
No, I think it's AZ GOP.
That's Alex
Maricopa
Culloden.
County. Yeah.
Our very
Yeah,
own
they-
Alex Culloden.
Right. So they asked to be permitted to submit a brief in support of our argument as amicus, which means friend of the court. So just additional arguments why the court should support one side or the other side, and the county defendants they didn't articulate any particular objection to it, so the judge agreed. Yeah, go ahead, and their brief is going to be reviewed, and the court will consider what their arguments are. And again, in their brief they very carefully laid out the things that we in a almost a summary fashion pointed to, said, look, here's the law that says the political parties have the special status, and their brief even digs deeper and makes it clearer in greater detail how the elections procedures manual by the Arizona Secretary of State has the force and effect of law and applies in this particular situation, and how the county is just blatantly violated. And we're just picking on them on the issue of keeping out political party participants.
Michael, we're almost out of time, and what I'd like you to do is put on your Swami hat and your crystal ball. What do you think is going to happen across the United States? We have been so disappointed with court after court after court, including the Supreme Court, on decisions that affect all Americans and, quite frankly, the world.
Well, look, if you're a conspiracy theorist or you favor those, then you will understand that by keeping all these cases from being fully explored, they're just protecting the bad actors that are in there. And even if you don't believe in conspiracy theories, then and you believe that the elections are run honestly, then why are they hiding the ball all the time?
Right.
Why is it such a huge deal? Which again just fuels this conspiracy theory. And I'm not a conspiracy theories. As far as I'm concerned, all of them are true or all of them are false. I don't really care. That's not the issue, because I will act the same way regardless. And the same way is let's get down to the truth. Let's get down to the facts. Let's stop hiding the ball here. And this is where John and I had talked about. The analogy that we presented to the court was that the VW diesel scandal analogy, and it's like, look, the point of what they're doing here, this audit, the reason it's pointless, the reason it's just whitewashing this, is because what they're failing to do is they're failing to actually subject this equipment to real world, like on the road driving conditions, like real conditions. And they're running it through these various test schemes where a system that is been modified to cheat these tests, to provide the expected results when it's being tested, but provide different results when it's being actually used, just like the VW diesel scandal. That's why this audit will never uncover that, because they're not looking for that. They're not setting it up that way. And that's why it's so important to make light of that and to point out the reason they wanted to keep out political party observers is because they wanted to keep people out that have institutional knowledge, that know how this is supposed to work, and that can point out the flaws and really make it clear that whatever they're doing here, they can call whatever they want, but an audit it is
We're
not.
losing them.
Well, we got our closing music coming up here. We sure appreciate you, Michael. Will you come
Yes.
back another time when we have a little better control over this phone?
Absolutely. I'd be happy to.
Okay, thank you for joining
Thank you,
us.
sir.
Michael, thank you.
Thank you, John, for being here again tonight. And
Always
wish
a pleasure.
It
got
always
off
is.
to a
Thank
little
you very
better
much.
start, but
I love his
we
animation.
ended on a high tone.
I love it.
So we're going to see everybody, I think, on Monday night for Backstreet Gossip.
That's right.
So don't you go away, and thank everybody involved in tonight's show. And we'll see you again next week.
And we'll keep fighting back.
Fighting back.